Adkt 0608 in the matter of amendments of Supreme Court rules relating to attorney misconduct. It's SCRS 99 through 123. It's a petition filed February 10th by the Board of Governors of the State Bar of Nevada. You maybe like to come speak, introduce this petition. Madam President.
Honorable Justices, my name is Paula Armeni, President of the State Bar of Nevada. The State Bar of Nevada respectfully asks you to support your support in adopting the amendments to the attorney discipline. They will promote efficiency and provide greater protection for the public. I will make some preliminary comments, but then I will ask Bar Counsel Dan Hoagie to come up and give a more detailed presentation and answer any of your questions. Our mission cites as one of its core responsibilities to protect the public. The State Bar of Nevada is committed to upholding the highest standards of professionalism and ethical conduct within the legal profession. We can achieve our mission by ensuring that attorneys who practice in our state meet these standards. Self-regulation requires the court and the State Bar to balance the public and the professional interests. Members of the public criticize attorney discipline as slow, unresponsive, and biased towards our profession. Attorneys, on the other hand, criticize attorney discipline as punitive, petty, and ignorant of the nuances of professional practice. Balancing these interests are challenging, but the State Bar believes these proposed amendments will benefit all stakeholders in the discipline process by streamlining procedures, promoting efficiency, and fostering fair and transparent discipline proceedings. The most significant amendment we recommend is a private admonition for minor misconduct. Other proposed amendments include protective orders, agency cooperation, compliance affidavits for non-reinstatement suspensions, Bar Counsel approval for conditional guilty pleas, and other procedural improvements. We believe that these proposed amendments to the disciplinary procedure rules are necessary and appropriate to promote a more efficient and effective attorney disciplinary process, which will ultimately help protect the public and maintain the integrity of our legal profession in Nevada. Thank you.
Thank you. Colleagues, do you have any questions at this time? No? Mr. Hoagie?
Thank you. May it please the court. Dan Hoagie, Bar Counsel for the State Bar of Nevada. I'm briefly going to outline just some of the amendments, proposed amendments, and then I'll address some of the comments as well. Feel free to interrupt anytime with questions. So with regard to admonitions, this will affect rules 102, 105, and 120. We're asking the court to replace public letters of reprimand with private admonitions. This is probably the most significant change, and it is in line with the ABA model rules. Now, as you're aware, the letter of reprimand and the public reprimand, which Nevada has currently, are identical in form and substance. There is really no difference between a letter of reprimand and a public reprimand. They incur the same costs. They are both public, and the only difference is that a screening panel can issue a letter of reprimand, whereas a formal hearing panel can issue both. A private admonition would inform the lawyer that their conduct is unethical, but without unnecessary stigmatization. It would deter lawyers from the same conduct because we would publish it in the Nevada Lawyer magazine, but we would omit the lawyer's name. So it'd be like some kind of pseudonym or initials or something like that. Lawyer A or something like that. Panels could use an admonition in subsequent proceedings as evidence of prior misconduct. So it would be something that would encourage progressive discipline. To avoid abuse and promote transparency, I think this was the problem with private discipline in the past. We proposed to adopt some limitations that were encouraged by the ABA also. Where discipline would be public in cases of disbarment, suspension, and reprimand, but when there's minor misconduct, so lesser misconduct, and that includes little or no injury to the client, public, legal system, or the profession, and when there's little likelihood for recidivism or repeat misconduct. In that case, a screening panel could issue a private admonition. And the limitations to that would be if the respondent received one in the last 5 years, then the screening panel would not be able to offer that private admonition, or any public discipline in the last 3 years. So if they had been suspended, for example, in the last 3 years, a screening panel would not be able to offer a private admonition. Only screening panels would be able to issue a private admonition. A respondent could object, obviously. It's more like an offer in a criminal case where that's a plea offer, a guilty plea offer. If the respondent doesn't accept that offer, rejects that offer, then they're permitted to go to formal hearing. But once bar counsel files a complaint, then the matter becomes public. And once you ring the bell, it's impossible to unring the bell. Procedurally, there's no way for a formal hearing panel to issue private discipline because there's no way to make what is now public to be private. I guess you could seal it after the fact, but if bar counsel had already given information from like a public records request, if the review journal had already requested information, we would have already given it to them, and the cat would be out of the bag. The bell would be rung. There would be nothing. It'd be impossible for us to make that matter private. And that's the largest one, or most significant change. We also propose some changes to confidentiality. Confidentiality, the big one, would be just protection orders. I think this, in practice, the hearing panels have fostered this ability to issue protective orders. There's just nothing in writing. So we have before asked a formal hearing panel to seal records, or respondents have asked formal hearing panels to seal records, but there's really no codified process to do that. And so we're asking that the court codify that process. It does happen today in practice. There's just no rule to back it. So we thought that would be appropriate to kind of clean up that issue. We also ask for the ability to share information with federal and state agencies. There's been some recent cases where the FBI has been involved. I can think off the top of my head, like Matthew Beasley, a very serious case involving $500 million worth of Ponzi scheme money. A lot of clients were affected, and the case was very, very large, very time consuming.
I'm sorry to interrupt. Would there be notification to the attorney that information would be disclosed prior to it being disclosed?
No, there were not in the proposed rule as it is written now.
Okay.
And so what we would obviously keep confidential information confidential, redact social security numbers, medical information, anything like that. But if it were something that would otherwise become public upon the filing of the formal complaint, then we would be able to share that with them early and hopefully receive that reciprocal cooperation from, say, the FBI or Las Vegas Metropolitan Police Department. We do work with them often just because our cases sometimes overlap, but it is difficult currently because we can't really share information until the matter becomes public. And so it's more of just an efficiency thing. And in all fairness, the ABA is kind of silent on this issue. The ABA model rule says that the Supreme Court, when it's making its rules, can decide whether or not they want to include other law enforcement agencies or not. And so several states do, several states don't at all. Currently, we don't. Our current rule allows Bar Council to share information with, like, the Committee on Judicial Selection or some kind of, or the other departments of the bar for admissions and things like that. We could share information that way, but it has to deal with a candidate for some kind of judicial selection or some kind of position in the law. Third, we propose an amendment to non-reinstatement suspensions. This again is just word for word with the ABA model rule recommends, and that's if an attorney is suspended for less than 6 months, they would file an affidavit with Bar Council saying, I've completed my suspension and I've followed all of the rules. That affidavit in and of itself we don't have any authority to block their readmission. They're still reinstated automatically, but at least we would have something that said that they followed all the rules. They didn't engage in the unauthorized practice of law. They completed all their conditions that the Supreme Court had issued during that suspension. And it just helps with compliance.
So currently, if I may, currently time runs out and then they're just reinstated without any further action.
Correct.
You're asking that not necessarily before that happens, but simultaneous when that happens, they have to file an affidavit to be reinstated?
Correct.
That's the recommendation?
So it'd be kind of similar to like Supreme Court Rule 115, where if an attorney is suspended, they'd have to file an affidavit saying, I've notified all my clients. If they don't do that, Bar Council really has no authority to do anything. It's more, sometimes the court can file a motion, or contempt order, or, show cause order, something like that. But otherwise, under Supreme Court Rule 115, it's just an obligation that the attorney has. It's more, kind of helps the court and helps them to recognize their duties and shows that they completed those obligations.
So at the 6-month mark, if they submit an affidavit and say, hey, 6 months is up, I've completed my obligations, they don't have to wait on anything further.
No.
Right? Just
no.
That affidavit's out there. They're now reinstated just by kind of operation of time and
Absolutely.
submission of the affidavit.
Yes.
And that's it.
Yeah.
Okay.
Yeah, the affidavit in and of itself would not, they would be reinstated just based on the time. It would not affect reinstatement. Now, for conditional guilty pleas, Supreme Court Rule 113 is in Nevada is different than what the ABA recommends. It's very similar, but the wording is just different enough to cause some significant confusion. I'm sure you read the comments, and Respondents Council in the comments stated, oh no, that rule's very clear. We have unilateral authority to negotiate with the panels. Now, of course, we're not implying that someone can't plead guilty. Of course, any respondent could come up to a panel and plead guilty. What we're saying is it doesn't make sense procedurally for us to prepare our witnesses. Let's say we have a half dozen witnesses ready for hearing that day. We're ready to go, and then Respondents Council shows up and says, I want to tender a conditional plea for a stated form of discipline that we don't agree with, and then essentially take over the proceedings. We have to tell our witnesses to go home. We have to cancel the hearing, and if the panel doesn't accept that, we have to get a new panel, schedule a new date. It just doesn't make sense. Anyone who's ever been involved in criminal law knows what a guilty plea agreement is, where both sides concur. No other state, as far as I know, in the United States allows a unilateral plea negotiation between a respondent and a hearing panel. And like I said, procedurally, it creates a nightmare for us. Going back and telling a victim or a client, hey, you're not allowed to speak today. They've offered something. And even if the panel accepts that, we don't really get a chance to present our case. They essentially plead based off of the pleadings. They'll say, I admit to everything in the complaint. I want a dismissal with a caution. And there's really nothing we can do.
So that would be happening now without someone turning to bar counsel and say, what's your position?
Exactly. That has happened in the past. Very rare, I will say that. Most respondents counsel don't do that, but it has happened in the past where they'll show up, the day of hearing and then say, I want to conditionally plead guilty and I want a whatever. Usually it's either a letter of caution or it's some kind of diversion program with some conditions.
Can I ask just a question, just procedurally on that? So you show up, your witnesses are in the back room, you're ready, and counsel says, I want to, the respondent says, I want to plead. Does that happen right then? So the determination about whether that discussion happened right then with the panel, whether they'll accept the proffer, does that happen right that moment?
Yeah. So the problem is if you read the rule, part 1 says that I actually have the language in here. So if you look at subparagraph 1.
Sorry, what rule?
113 of the current rule. Says an attorney against whom a grievance or complaint has been made may tender a conditional guilty plea. Now, in the ABA model rule, that says to bar counsel. But I want
to know what happens here in Nevada. So
right. In Nevada, it just says they may tender, and that's approved or rejected by a hearing panel. But subpart 2 is what I was getting at. Subpart 2 says a continuance in a proceeding on the basis of a tendered plea shall be granted only with the concurrence of bar counsel. But essentially, respondents counsel argues that bar counsel has no say in it. And so we have no say whatsoever, and essentially they present their deal to the panel, and the panel either accepts it or rejects it.
Okay, I'm just trying to understand. So your witnesses are over there, they say, I want to plead. And you either object, or you object to that acceptance of plea or not. And the panel right then and there says we'll take it or we won't. Is that what happens?
Usually they deliberate outside of presence, but
so they
yes.
deliberate outside. This is all happening. This is all real time.
Yes.
Right?
Mm-hmm.
So why would you let your witnesses go? So if the panel comes back and says, you know what, we're not accepting your proffer, then why can't you say, I want to call my witness? I don't understand. I haven't been to this, so I don't understand how this flows, that it's
I think historically it's been the practice, if a panel has rejected a guilty plea, even one that we consent to, then we get a new panel, just so that new panel doesn't know all those facts from the previous guilty plea. That the respondent was willing to plead guilty and had admitted all the facts. It prejudices the respondent, is the theory. So historically, anytime a panel has rejected a guilty plea, then we get a new panel, and that's the problem. So our proposed amendment would just clarify that this is a true guilty plea where respondents would negotiate with bar counsel. We would agree to some sort of stipulated facts, stipulated discipline, then propose that to the panel, and then that would also go to the Supreme Court for review if it were a suspension or disbarment. There's some other minor changes to bar counsel's duties and authority. This is essentially just an adoption of the ABA model rule for some clarity. One thing that is is important to me, I will say, is the ethics calls and opinions. We're in a very difficult situation because we man the ethics hotline, which is fine. We're willing to help out attorneys, but we're put in a difficult spot. It was probably about 18 months ago, I was called into the court because plaintiff and defendant had both called into the ethics hotline and been given different advice. The problem is the underlying facts were a little bit different, and so the advice came back different. And I got called in saying, all right, what's going on? What's happening? And we tell them repeatedly, hey, when we're giving you ethical advice, we don't have the whole story. We can't give you a formal opinion. We're just kind of helping you in the right direction. But I know that members really want a very specific formal opinion, and we can't do it. And so if we had some support in the rule that says, hey, we can't do it, I think that'd be better for us to turn to and say, look, we can't give you a formal opinion.
But are you then saying that you wouldn't give the telephone call where someone has kind of a burning ethics question and wants to get some guidance, even if it's short of a formal opinion? You would not do that anymore?
No, we would still man the ethics hotline. We'd still give them advice. We just let them know very specifically, this is not a formal opinion. Do not rely on this. Don't put it in your motions. Don't tell the court, hey, I talked to bar counsel and they said this is okay or whatever, which usually happens. And then we get in a difficult spot. It also is concerning because sometimes they'll tell us, hey, I did X, Y, and Z, and we'll say, okay, based on what you told me, that's fine. Then the client will later complain, and we find out it's more than X, Y, and Z. And they'll say, well, you told me I was okay. So we get into a conflict. Also with probation, this isn't a significant change. There technically is no rule in the Supreme Court rules that allows for probation. If you look at, under the letter of reprimand or the public reprimand, a panel can issue conditions, but doesn't really talk about probation or, procedure for probation. So we just ask that that be codified just so there's procedure. It's very similar to what we already have for like Rule 105 for diversionary programs, where there's just a structure very similar to that. And then we propose to adopt the what we call the learner factors. They're the ABA factors, and it promotes consistency. What it does is it asks a panel to first determine if there was a rule violation, and if there were a rule violation, then what was the attorney's mental state, and then what injury was caused to a client, to the profession, and then finally whether there are any aggravating or mitigating factors. And so this court's always recognized those, but it's not codified, so we thought it would be good to codify it. Would help out panels. So that's a basic rundown of the changes. I did just want to address a couple of the comments, and I'd be happy to answer any questions after any additional comments as well. But one of the major comments is a task force. We're not necessarily against the task force. However, I will say that the State Bar of Nevada, the Board of Governors convened a task force in 2021 to go over discipline. Spent about a year talking about different things. Also, these rules, most of them are word for word, and all of them are, paraphrasing straight from the ABA model rules. The ABA has spent 50 years drafting these rules. The most latest revision was in 2020, and there has been thousands of hours of discussion on these from professionals all over the United States. And I can tell you that these rules, for example, like the private admonition, and whether or not the private admonition can be issued by a hearing panel, once you go to a formal hearing. If you go to Louisiana, for example, that's the way they've always done it. If you go to Louisiana, you can't get a private admonition from a formal hearing panel. The benefit of that is that there's lots of case law to support that. There's no due process issues. It's been well litigated. There's lots of case law. There's lots of states that adhere to that. And so we wouldn't be breaking ground. It'd be very familiar territory.
If I may, did the 2021 task force address these proposed changes that you're proposing here today?
The task force addressed discipline structure more, and the ultimate result was we don't want to change the structure. The task force had discussed whether or not maybe having a full-time discipline judge would be appropriate, or maybe restructuring how the panels are formed. And ultimately they found, no, let's keep it how it is, but let's make some changes this way. So to answer your question, not directly, but yes, this is basically the result of the task force was, let's just modify the rules and keep the structure as is.
Mr. Hoagie, I just want to understand then currently how this system is. So without admonitions being available currently, there's letter of reprimand, which is also a public form of discipline, right?
Correct.
And letter of caution. Tell me what a letter of caution is, or how that has been used.
The letter of caution is a dismissal with cautionary language. Essentially, it dismisses the case. It goes on a 3-year track, just like a regular dismissal. So after 3 years, the Bar Council will delete that record, and we won't, if anyone asks, we won't provide that. We keep them for 3 years, just like we keep all dismissed cases. But it does give cautionary language saying, look, you came very close to violating the rule, or whatever helps that attorney to improve in the future.
But it's only used if a violation is not found. Is that correct?
That was the original intent. So, for example, if a lawyer doesn't break the rule, but they came really close, I think a good example is like a lawyer that connects their IOLTA to like a Venmo account. It's not technically a rule violation, but we will send them a letter of caution saying that's a bad idea. All right. So that was the original intent, but because Nevada has a big gap between dismissal and letter of reprimand, which is a public reprimand, it's kind of turned into a catch-all for everything in between there.
And so, and I'm sorry, I know I have the rules in front of me that you're proposing, but with the proposed addition of the availability of a private admonition, you're proposing to eliminate the letters of reprimand as well as letters of caution, is that right?
We're proposing to eliminate the letter of reprimand.
Okay.
And we are taking the letter of caution out of the delineated or enumerated forms of discipline and just putting it into the dismissal category.
Okay.
Meaning you can a panel can still recommend a dismissal with cautionary language, but it's not under the structure that says this is a form of discipline.
So then if a screening panel reviews the information provided and feels there is a violation, but that a private admonition is appropriate, then they can do that. And then the attorney, if they want to dispute that, then it would go to a public type proceeding.
Exactly. So a respondent, if a hearing panel, if Bar Council recommended and the hearing panel adopted that recommendation, or if the hearing panel rejected Bar Council's other recommendation and on their own said we want to issue a letter of reprimand, then we would notify the attorney and they would have 14 days to either accept that or reject it. And if they reject it, then we will file a formal complaint and it will go to formal hearing.
And so, so anything that makes it past the screening panel stage becomes public.
Yeah, that's accurate, because if it's dismissed, it still becomes public, but it's dismissed.
Because some of, as you saw, obviously, some of the comments are suggesting that it should be permissible to still have a private admonition even once it goes to a disciplinary panel if they think that's all that's warranted under the circumstances. So would you respond to that, or how do you respond to that?
Well, the only way, procedurally, it really wouldn't work if for a true private admonition. I guess what Respondents Council is arguing for is kind of like some kind of hybrid, where it'd be private in the sense that we don't publish it in the Nevada Lawyer, but for all intents and purposes, otherwise it's public. If the review journal asked me for a copy of that, we would have to provide it, because it's basically already been public. There was a formal complaint filed. They already had that information. The bell's been rung. But we wouldn't publish it, I guess, would be the only difference.
Yeah. Okay. And sorry, I thought that was one more thing.
I think a good example, like I said, Louisiana. If you received an admonition, a private admonition in Louisiana, it would be private. No one would know. Even if the review journal asked for a copy, they wouldn't receive that. It'd be true private. It's kind of like our diversion is currently. So if someone has a substance abuse issue and the screening panel recommends a diversion, if the review journal asked me for a copy of that information, we would tell them no. We don't provide that for a diversion.
Thank you.
Just a couple other comments. Like I said, there is no due process issue. I know due process was mentioned several times by Respondents Council in the comments. I really like this comment on Model Rule 11 from the ABA. This is what they state. The fact that refusal to consent to the admonition or probation subjects the respondent to formal charges and potentially more serious discipline does not violate due process any more than does the fact that a person charged with a crime is subject to conviction of a more serious offense when he or she refuses to plead to a lesser crime. So, like I stated, it's very much like an offer and acceptance. The screening panel will issue that as an offer, not as discipline. And I think Response Council really frames it as some kind of ex parte discipline, but it's not. It's an offer that they can accept or reject. They are correct that it is ex parte, but there's no discipline imposed. It's only if they accept that is it ever imposed. So, like any offer, they can reject that and go forward. They don't have to. It's not a true appeal. In the rule, our rule, it does say appeal, but it's not a true appeal. That's not the language from the ABA model rule. I don't know where we got our language from, but it's, our structure is very, very similar to the ABA. That we just have a couple words that I think creates that confusion, where we call it an appeal, and that it was like some kind of formal discipline that was already imposed. And so I think just framing it differently as an offer instead of, no, you had some kind of star court where you weren't present and they issued discipline without your presence. I agree that sounds really bad, but that's not the way that the ABA looks at it. And like I said, this has been litigated in other states. No, there's never been a case where they've said that's a violation of due process. And I think I addressed the issues in the comments about the 6-month suspension. Again, it wouldn't affect reinstatement whatsoever. It's just a requirement for them to do upon the end of their suspension. We wouldn't be able to, say, extend their suspension in any way. I think we've addressed how the questions of the unilateral conditional pleas. I did want to, there's a lot of discussion in the comments about the limitations to the admonition. This comes from Model Rule 9. For example, a panel would not be able to issue a private admonition for a lawyer that misappropriated funds. Now, I think one of the comments was, well, essentially, how are they going to tell whether or not the lawyer misappropriated funds or not? I guess that's fair. It is ex parte. I will say this, though, the Bar Council, we never issue a recommendation without notifying the attorney first and receiving comment from the attorney, and we present those comments to the screening panel. So if the attorney has a defense, we will present that defense to the screening panel. So if we've gone through the bank records and the bank records are pretty clear that there's misappropriation, we'll submit the bank records and they can have an excuse or defense, whatever it is, as my bookkeeper or whatever the defense is, we will also present that to the screening panel. But nevertheless, if there's any implication of misappropriation, that's just not appropriate. So what we're saying is a panel shouldn't say, okay, you've misappropriated funds, so we're going to offer you a private admonition. We should never do that. And there's also some for any misconduct involving dishonesty, deceit, fraud, misrepresentation, if the respondent has been disciplined in the last 3 years or received another private admonition in the last 5 years. Those are important because it really slows down that private nature of discipline for a repeat offender. I think the best example is this letter of caution from March 2010. In 2010, it says, "Dear Mr. Graham, the screening panel of the Southern Nevada Disciplinary Board reviewed your grievance. The panel determined that it would not take formal disciplinary action against you. Accordingly, the panel directed this grievance to be dismissed and the file closed. However, the panel instructed the State Bar of Nevada to caution you regarding your ethical obligations regarding the proper management of attorney-client trust accounts. As you know, the Nevada Supreme Court and disciplinary boards of the State Bar are very concerned that client funds be handled appropriately. Accordingly, attorneys must ensure that their trust accounts are properly maintained. As such, a negative balance almost always amounts to a per se violation of ethics rules." We know that 7 years later, Mr. Graham was arrested and sentenced for misappropriating over $16 million worth of client funds. And had the panel been restricted from issuing a letter of caution or private discipline for misappropriation, then we don't know how many clients would have been informed of that, may not have hired them, may not have lost their life savings.
Before we move on, just from the admonitions, why can't someone get an admonition after the filing of a complaint? I appreciate that you're like, well, the cat's kind of out of the bag. But there's still a benefit to the attorney that it's a private admonition is the resolution. So what is the purpose between saying once we file a complaint, that's it, now we're in discipline territory, discipline or bust? What is the?
I think the best way to look at it is to look at a reprimand. What's the purpose of a reprimand? A reprimand, in essence, tells the attorney what they did wrong and is published. Right? It goes on the record, and if it's lesser misconduct that doesn't warrant a suspension or disbarment, then you have the reprimand there. If you go to a formal hearing panel, now that complaint is public, everything's public, someone could attend the hearing if they wanted to and know everything that goes on. Then the panel says, we're going to issue you a private admonition. At that point, it's more appropriate just to issue a reprimand, if a reprimand is appropriate, because it's already public. So what's the point of now not of hiding that from the public once it's already become public.
What if the attorney convinces the panel that it's minor misconduct, there's little or no injury to a client, the public, the legal system, or the profession, and there's little likelihood that they're going to repeat the misconduct? I mean, what if sometimes a complaint gets filed and then you learn more about it, or you hear from other people, and at that hearing they talk about it, or they say, I want to negotiate because this is, I don't deserve to be in this territory. And so the fact that some member of the public may randomly wander in and watch it, or it can be found, doesn't mean at the end of the day there may not be a benefit to the lawyer from not having that published in the Nevada Lawyer under their name, or having that be a private reprimand. I'm just wondering it seems like kind of an artificial barrier to a resolution. And I could be missing something, but just what I'm trying to understand.
Well, that's a fair point. I think essentially what you're saying is if they score out for an admonition, meaning there's little or no injury and there's little or no chance that the attorney reoffends. I would say even in that case, really there's no difference between an admonition and a reprimand other than the fact that one's public and one's not.
Is there a difference for future consequences if they have future discipline or future bar complaints?
They're both prior discipline. So I guess you could say that you could argue under progressive discipline, if they gave it an admonition, maybe next time they could issue a reprimand, and that's fair.
And if you were going to do a non-scientific poll, do you think the lawyer who's the subject of the complaint would think there's a difference between a private reprimand and a public reprimand?
Yeah, absolutely. But also, I don't want to mislead an attorney by saying, hey, you're going to get a private admonition at the hearing, and then later they come and say, hey, how did so-and-so know about this? Mm-hmm. Now, that puts me in an awkward spot, which, we've already been in this year with a certain candidate. We had a letter of reprimand that went public, and then, of course, it was, hey, the state bar did this. And we didn't, but it puts us in an awkward spot once the bell's been rung and the information's out there in the world. Then it comes back on us. Hey, this is supposed to be private now. You didn't protect it enough. That's why I don't like it. To me, there's not a significant enough difference between an admonition and a reprimand to put me in that spot. So, well, thank you for your time. If you have any other questions, I'd be happy to address them.
Anyone else have any questions at this time? No? Okay, thank you. Just for the record, we did receive a number of written comments. Those have been disseminated to my colleagues, and they are made part of this record and available to the public. Do we have any speakers, anybody who would like to speak on this topic here in Las Vegas? Well, we'll go alternate. I see some people. Would anybody like to come make public comment? This is the time.
Madam Chief Justice, Justices, may it please the court. My name is David Clark. I'm an attorney here in Las Vegas with the firm of Lipson Nielsen. And along with my law partner, Jeannie Isaacson, we submitted written comments. I won't go through all of them because we only have 2 hours left. But I want to highlight certain things. Thank you. Thank you for giving us the opportunity to offer public comments and written comments. As most of you probably know, between Ms. Isaacson and myself, we have almost 25 years of experience in the Office of Bar Counsel, as Assistant Bar Counsel, as Deputy Bar Counsel, and as Bar Counsel. And since that time, we have put together probably another decade representing respondents before the State Bar. As the court well knows, we are a self-regulating profession. And we are sworn officers of this court. We uphold the court's rules. We are guardians. We are charged with being guardians of our clients' interests and guardians of due process in the legal system. But in order for us to fulfill that charge, we must practice and live it ourselves. And that comes home to roost here in the rules of discipline, rules of professional conduct, and the disciplinary rules of procedure. These are the rules, Supreme Court rules, that we have sworn an oath to uphold that we are charged with observing and enforcing. And ultimately, if there's a problem, we are judged by them. And if we are going to protect the public, it starts first with us. And that attorneys are fit to practice law and to represent their clients. And the main points that I would highlight, and my colleagues will follow up with if I miss anything, is that I would submit that the changes that have been proposed with some unnecessary haste, and perhaps not with a full perspective of all the stakeholders here. Mr. Hoagie mentioned that there was a task force. Not that the world centers around me, but I don't recall ever hearing about a task force and not one with public hearings. And I think that a task force would bring a more fulsome discussion, would help vet the rules, would offer different perspectives from all sides, even the public side, and the respondent side, and the state bar side, and the judge's side. I think that given the importance of these rules, given the impact they have on our practice, and we are a self-regulating profession, that a task force would be wise to look at the rules as a whole. The state bar talks about, well, a lot of these are adopted from the model rules. Well, you can either adopt all of the model rules because they're an organic system, but if you start to pick and choose, you may miss some checks and balances in certain areas. I'll give a summary of the main points that we brought up in our written comments. First, replacing the letter of reprimand with an admonition. To take a step back, before 2007, there was a letter of private reprimand, then a public reprimand, and then suspension disbarment. The screening panel issued a letter of reprimand. It was proffered, and the attorney had 14 days to accept it or reject it. 14 days to either object to it or it was imposed. The attorney could then opt to appeal it and say, I want an informal hearing or I want a formal hearing. An informal hearing stays confidential. When that happened, the entire file was just transferred to a hearing panel and to respondent, and they reviewed the proposed letter of reprimand. On the one hand, they could not impose a greater discipline. They could either affirm it or reduce it. On the other hand, the attorney agrees that they can't appeal it. Whatever this panel decides is done, and it stays as a letter of private reprimand. If they said, nope, I don't like it at all, I want a formal hearing, then the bar counsel would file up a formal complaint, and then, everything's on the table. They could impose whatever they felt was necessary. But the important thing is that there was a review and adjudication of the merits of that letter of reprimand. In 2007, the rules changed and it became publicized. It became a public letter of reprimand. Still took a few years before the word private was taken out of the rule. And Mr. Hoagie is right. There's functionally no difference. A letter of reprimand is published in the Nevada Lawyer. It's pegged to your attorney website page. I think the only technical difference with a public reprimand is it's supposed to be submitted to a national database that I've actually never seen or heard of or communicated with. I assume it exists out there. But a letter of reprimand was published. It was still published in the Nevada Lawyer, but without the attorney's name. It was a letter of private reprimand. It still educated the public. It still is prior discipline, so if the attorney does it again, it's an aggravating factor. What the rules here say, or what the proposed rules say, is that we're going to go into a screening panel. It's ex parte. It's confidential. It is non-discoverable. It's all privileged. The work product of the bar counsel and deliberations of the screening panel are privileged. No one will ever know what they did. And then they will issue a proposed letter of reprimand, or in this case, an admonition. Replacing the letter of reprimand with an admonition. You have 14 days to reject it. If not, it goes on your record. However, if you reject it, you can't use it again ever. So the screening panel has now made a final decision that regardless of the facts that come out, regardless of the charge we have in the ABA Standards 1.3 that says every discipline must fit the circumstances of that lawyer, a formal hearing panel can't use an admonition. Once the facts are considered and cross-examined and presented, the panel doesn't have that choice. It's either a dismissal or it's a public reprimand.
Well,
And the attorney has
Mr.
lost-
Clark, how would you respond to Mr. Hoagie's point that by that time there's a public record of the proceedings anyway? So what's the point of a private admonition at that point?
Well, now they're all public. Imminent dismissal is public. If there's a formal hearing set, formal complaint filed, and there's a dismissal, that's still public. Under the rules, it's all public. I don't think there's a lot of interest in it. And an admonition is not broadcast with their name. It's broadcast, anonymously. I just had a hearing where an attorney has a second DUI with extreme bodily injury, failed to timely report the conviction because he was negotiating a plea. But at the end of a long hearing panel, the panel imposed a letter of reprimand, not a public, but a letter, because based on the facts as they all came in, based upon the panel's assessment of the attorney in front of them, they said, letter of reprimand.
Okay, that's public.
It's public.
Okay.
It's public now. So I think after a hearing, if they say no, we're going to give you an admonition, people can find out. I suppose even in the old rule with a letter of reprimand, those files became public. They weren't broadcast, they weren't published, and they remain confidential. But even, all the records are public now. If somebody wants to go in and find them, they can find dismissals. They can find letters of caution for 3 years. So I don't know that it has that much of an impact. And I don't see that by virtue of the fact that, well, we're now in a public hearing, you no longer get this species of discipline, even though it may be best suited for misconduct, it may be best suited for your circumstances, it may be best suited to achieve some rehabilitation.
Well, how does that work under the ABA rule model?
Under the ABA model rules, there's additional vetting of the findings of the screening panel. They have an additional tribunal that reviews it again, and there's attorney input. Here, there's no input by the attorney. A screening panel, and I'm not suggesting Mr. Hoagie would ever do this, but a screening panel looks at the recommendation of a bar counsel. The bar counsel recommends violations of A, B, C, and D. They say, okay, we're with you on A and B. We don't agree with C and D, dismiss those. Bar counsel will then offer the letter of admonition for A and B. The attorney says, no, I don't want to take it. Under disciplinary rule 9, as it exists now, bar counsel can add back in C and D and just completely circumvent the screening panel. The rule says it's like they can add charges, they can add facts. So the attorney is presented with a choice. Take this level of discipline without knowing any of the presentation, without knowing any of the deliberations of the screening panel. What were they considered?
So you're saying under the model rules, the ABA model rules, the attorney has a right to more of a hearing and can still go after an admonition as the form of discipline?
Yes, there's still a hearing with more attorney, but I'm not really sure where the screening panel system came from for our system. Maybe Mr. Baer has better knowledge of that. But the attorney has to make a decision. Do I take this admonition, not knowing what was said to the panel, not knowing what facts were given, or I reject it and don't know if something else is going to be added to it, which if it would have been, maybe I would have taken it. But now I'm stuck facing public discipline.
Well, but right now there is no private discipline.
True. There is no private discipline. After 2007...
I mean, we don't have admonitions, so you can't line it up with the ABA standards. If you go in the ABA recommended discipline, they talk about admonition and then they talk about reprimand and suspension and disbarment. We don't have admonition.
Correct.
So this, in a sense, is affording an attorney who is above the dismissal with a letter of caution or cautionary note and some form of public discipline. So it's, I would think, advantageous to the attorney to have an admonition. So your opposition isn't to the admonition, but rather to the lack of safeguards on that option?
Yes, no, I support an admonition. I support putting back in the private option.
Okay.
I just feel that discipline should be available to a formal hearing after it has cross-examined all the facts. After the attorney has had an opportunity to be heard and to present evidence and to cross-examine.
I was misunderstanding you. I was perplexed by why you were arguing that way.
Oh, I'm sorry. I apologize for misspeaking on that. Briefly as to conditional guilty pleas, in my experience as bar counsel, there was never one tendered unilaterally. It was always went through bar counsel. So I agree with that. I've never seen, somebody come and say, I want to offer a plea on the day of the hearing. I have in the past submitted a plea under Supreme Court Rule 113 and NRCP 68 as an offer of judgment. I have no idea whether the court would even uphold something like that in a disciplinary matter, but that's the only time I've ever unilaterally proffered a conditional guilty plea. But this court delegates its regulatory authority to tribunals. And under the proposed change to conditional guilty plea, the gatekeeper is no longer the tribunal. The gatekeeper is bar counsel. They can say, nope, I don't want to take it. Nope, it's not. I've got too much invested. I just disagree with you. The panel can't hear it. And I think that's wrong. I think it should be the panel that decides whether they can impose it or not. And just to point out, under the current SCR 113, it says that the tendered plea shall be filed with the bar counsel's office and approved, modified, or rejected by hearing panel. So it is still filed with bar counsel. You got to give them notice of it. But then the panel looks at it. Under the model rule 21A, the tendered conditional admission shall be approved or rejected by the board and subject to final approval by the Supreme Court. So even though it is filed, may tender to disciplinary counsel an admission, it is still considered and approved or rejected by the board. So even under the model rule, bar counsel is not the gatekeeper. It's always the panel. A few more. Under confidentiality, I think the justice was right in pointing out if bar counsel is allowed to disclose certain information, which could be very serious, particularly if it's a law enforcement agency asking you about it, whether the attorney or maybe even a grievant should be notified of that. It's one thing for me to be working on my discipline. It's another thing for me to be making statements that may violate my Fifth Amendment rights, and that can be used and republished to other law enforcement, particularly if it's in a non-public setting. Because until a complaint is filed, it's all confidential. So if I make a statement in the grievance process, and then while that's pending, or if that's then disclosed or that's then dismissed, bar counsel can take that statement and pass it along to law enforcement. And I wasn't aware of that. I didn't agree to that, and that was beyond the scope of my publication. Non-reinstatement suspension. If you're suspended for 6 months or less, you're automatically reinstated. However, upon suspension under the rule, you still have to file with the Supreme Court and bar counsel within 10 days an affidavit saying, I've notified everybody, I've notified my clients, I've notified opposing counsel, I've notified the courts. And if you don't do that, then you're in trouble for that. So that's already in the rule. To require an affidavit at the back end saying, I've completed my 6 months, I haven't done anything bad, check on it, that's fine. I don't really have a problem with that. I just wonder if bar counsel does say, well, hold on a second, I have problems with this and this. How does the public get notice of that? And how long can bar counsel hold on to that? Is there a process for that? Is there saying, well, I can put an administrative hold on your reinstatement because I think you violated the terms of it? Or am I reinstated and then you can, file a complaint or a grievance, which you can do now anyway. If I have to file a back-end affidavit, what can bar counsel do with that? That's not clear in the rule. The other thing I brought up in our written comments is there's an amendment that says, and it's under the model rules too, You can't file for reinstatement, if you have to file for reinstatement, until your term of suspension is up. So if I'm a year, I cannot file until that year is up. The amendments also say 30 days for complaint, 30 days for hearing, 60 days for record on appeal. That's now 4 months that's automatically added to every single suspension, regardless. And if you look at the model rule commentary, and I have it in our written comments, even the model rule commentary says if it's a year, you can allow up to 6 months for them to start the process, so that you can't enter an order of reinstatement before the year, but you can get the process started so that you don't have to add on 4 months, 6 months, 8 months automatically to every suspension. If you suspended me for a year, I served the year, and I've demonstrated my fitness to for reinstatement, I should be reinstated after a year. That was my sanction, and that's what I should serve, because that tells the attorney a year is a year.
Mr. Clark, which rule are you referring to?
I'm sorry?
Which rule are you referring to?
Rule 116?
Thank you.
2 more points. One on probation. Codifying probation as a sanction, that's under ABA standard 2.7. That's already there, but yes, we can codify it. But I'm confused as to why a probation cannot be expunged. Mentoring and a diversion can be expunged, but a probation cannot be expunged. Does that put probation as a species of sanction above like a public? Is it a public sanction? Or if all I get is probation, and I've done the probation, I don't get a permanent mark of a letter of reprimand or a public or anything else, why can't the probation be expunged if I've done rehabilitation? I didn't see any reasoning for that or any basis for why that would be. Bless you. We already have under Supreme Court Rule 105.5 diversion, which if you complete the diversion, then it's all expunged, and people say, look, and the bar counsel will say, there's nothing here. So that encourages people to either get into treatment, to get into law practice management, to do whatever it is that's their particular, demon, and get that fixed. And after that, if you've removed it and you've completed the diversion, then you're good to go again. And finally, with and I agree with the learner factors, so I think that's fine. Finally, with the additional proposals, when bar counsel says a screening panel cannot issue a letter of reprimand or an admonition if there's a finding of they stole, or there's dishonesty, or a finding of fraud. Those findings are made by the screening panel, and once they make those are permanent. And again, we get back to the spectacle that it's a confidential, and bar counsel uses the term star chamber. It's a star chamber that's making findings of fraud, which are already subject to a higher standard, and I have no chance to even respond to those. They're making findings that it implicates misappropriation, and I have no chance to even respond to that. So if they're going to make factual findings, then I should be involved. So I would submit that only factual findings that can be binding on me are factual findings where I have an opportunity to be heard. And that, I think, is where it boils down to. And I'll answer any other questions, but then I'll let others speak.
No? All right. Thank you, Mr. Clark.
Thank you.
Members of the court, good afternoon. I'll be very brief. I think my partner very articulately indicated our objections. There is nobody in this room that doesn't understand and agree that protection of the public is number one. We all agree to that. And that bar counsel has to be able to effectively do their job. No one knows that better than me. Mr. Hoagie mentioned Robert Graham. I prosecuted Robert Graham. I will never forget the day I figured out what he did. I will never forget holding those widows, the orphans, and the children, and having to tell them their money's gone. So I take those things very seriously. I did when I was a prosecutor, and I do now. That's not what these amendments are about. When talking about the reasons for these amendments, I heard the words efficiency. I heard the word streamlining. That's different than effectiveness. That talks about making things easier. And I'm not saying streamlining and efficiency aren't good things, but they are when to get them, you're sacrificing due process. And that's what's happening here. The ABA models are an excellent guide for Nevada in how to do things, but we can't piecemeal it. There's a whole part of the ABA model for disciplinary enforcement that we don't have. It's at the beginning, where there are hearings on minor misconduct. The attorneys have an opportunity to be heard. The attorneys get their lawyers present. I was counting in my mind, probably over 200 screenings in my day. And I am not suggesting that the State Bar does not tell the screening panel what the respondent's position is. They wouldn't not do that. But they're not going to do it like I would. They're not going to get in there for their clients like we do. They're not going to passionately argue the positions for the attorneys. And that's what's missing. Right now, the admonition is in effect a carrot stick situation. It's attorney. This screening panel decided you could have this. You didn't get a chance to speak. You didn't get a chance to be heard. We don't know what was said, but we know this is what they're going to give you. And if you don't take it, it's gone forever. It's gone forever. And now you're going to have to go spend $25,000 at a hearing. And at the end of it, you can't have that again. You better win, or you're going to get discipline that's going to be on the public record. That's the effect of what this amendment would do.
But now there's no private admonition available at all. So is this an improvement?
Aha, I have a simple solution to this. I was thinking of it there and the ideal light bulb went off. SCR 121 could be amended. It's a very simple amendment that could amend in situations where an admonition is the discipline that could be protected. It's a very one-line, simple addendum, and it solves the problem. It protects the attorney's privacy. It protects the decision. It protects the admonition in totality. And going to Mr. Hoagie's example of Mr. Graham, I want you all to know that once I realized what he did, the first thing I did is went back and I scoured our history because I was going to chew some butt of anyone I thought missed him. He wasn't there to find. I looked at everything. The changes that we had to make after Graham were made, but they were done in the form of when do we order trust account records? How often do we do it? Do we keep track of the number of dismissals? Do we have a history on the attorneys? Those things were done. Bar Council did a wonderful job at doing that. They have done those protections. The letter of caution that was handed out in that case, unfortunately, I have to say was appropriate based on the information they had at the time. He wasn't there to find yet. Nobody wishes more than me than he had been, but he wasn't. And these rule changes don't fix that. They don't change that. And all we're asking is the opportunity to be involved in this process. Mr. Hoagie talked about the task force from last year. I wasn't involved in that process. Mr. Clark wasn't involved in that process. We used to, even when we had panel training, we used to involve respondents' counsel in these things. Bill Terry was a fixture in these things. God love him and I miss him. And I know he'd be standing right here saying the exact same things I am today. We want the opportunity to be heard to help come up with a system that does accomplish that does protect the public, that does get the job done but not at the expense of the lawyer. That is their license. We take away their right to make a living. It shouldn't be easy. I understand it has to be effective, but it can still be fair. And that's all we're asking for with the task force and with the changes we recommend. Thank you.
Thank you. And for the record, that's Ms. Isaacson, correct? Thank you. Counsel?
Good afternoon. For the record, my name is Dennis Kennedy, and my partner and I, Josh Gilmore, filed a memo. I'm going to speak briefly on a couple points, and then Mr. Gilmore is going to follow me. What you've heard so far is some very, very competent testimony and thoughts by people with particular expertise in this area. They focused on the details and the nuances of these proposed amendments. What I'm going to do, with the court's permission, is get down a little deeper into some substance. As I see it, speaking for myself and for, let's say, the other 12,000 members of the bar who aren't here. And I think today I see them as my constituents. And the points I'm going to make, I think, are very important to all of them. And I have really 2 points that I want to make, both very substantive and go to the heart of these proposed rule amendments. The first is, and I do a lot of work in this area, my constituents ask me what rules are going to apply. The Supreme Court issues my license. What rules am I judged by the body that issues my license and can take my license away? The answer to that right now is very easy and very clear. The rules of professional conduct as adopted by this court and the rules of the Supreme Court, the SCRS, and the rules of professional conduct. That's the way it is right now. The bar has proposed, however, an amendment to the current rule. The current rule is 101.1. And that rule, which talks about grounds for discipline, it is grounds for discipline to violate or attempt to violate the rules of the Supreme Court or the Nevada rules of professional conduct. Real easy, real simple. It's been that way for quite a while, and we all understand that that's how we're judged. If you issue our license, we abide by your rules. You evaluate our conduct under your rules. The Board of Governors and the bar wants to change that. They want to change it to eliminate the Supreme Court rules and to say it's grounds for discipline to violate the Nevada rules of professional conduct or any other rules of this jurisdiction regarding professional conduct of attorneys. My question is, what does that mean? What does that mean? Do we all know what all the other rules of this jurisdiction governing the conduct of attorneys are? The answer would be not a chance. Not a chance. But what this amendment says to this court is the Board of Governors now wants you to enforce against lawyers and administer discipline to lawyers for violating rules that you never considered and you never adopted and over which you have no control. And by the way, rules as we all sit here today, we have no idea what they are. Okay. So any difficulties there other than the sort of transcendent difficulties? Yeah, this is not a hypothetical. About a month ago, the Board of Governors adopted rules which it called its creed of professionalism and civility. And I assume everyone has seen them because they went out to everybody in the bar. So I don't have to do hypotheticals when we talk about this court enforcing rules of lawyer behavior that exist in this jurisdiction. We can start right here with the 1 month old set of rules that were adopted by the same people who are proposing this amendment. Is there a connection between the two? I don't know, but it's what a remarkable coincidence if there's not. Let me take a couple of excerpts out of these rules. A lawyer should always show professional courtesy and professional integrity in the fullest sense of those terms. Bar counsel files a complaint against me and says, well, Mr. Kennedy didn't show those in the fullest sense of their terms. And Mr. Kennedy would say, what does that language mean? No, he has to be disbarred because he didn't do that to the fullest extent of their terms. And the next paragraph. These rules are designed, to resolve human and societal problems in a just and peaceful society. Okay, I agree with that. Am I going to be disciplined because I didn't contribute to a just and peaceful society? This court would never adopt a rule that said that. Because the first question is, what does that mean? And we'd all say, we don't know. But the bar says, let's change Rule 101.1 to say that this court will enforce these rules and all other rules like them. For example, the Clark County Bar Association, which is near and dear to my heart, has its own set of rules for lawyer conduct. And they're all very vague and very general and very aspirational, and that's great. But if you're asked to specifically define them and apply them to some conduct of a lawyer for discipline, I suspect that this court, at least the argument which would be made is, it's not this court's rule, and by the way, we don't even know who adopted these things. And this court should not enforce them, having had no input into them. Now, here's another difficulty. The bar, the Board of Governors, and this is on the second page of these rules, the bar cannot now say, well, these are merely aspirational guides that we all aspire to. Because I'm reading off the top of the second page, it says, while these standards are voluntary and not a basis for litigation or sanctions, violations of these standards may trigger sanctions under Rules 4.4 and 8.4b and others. Okay? How do you enforce that? You say, well, the first part of the sentence says these are voluntary, and the second part of the sentence says, yeah, but if you violate them, you can get sanctioned under the rules of professional conduct. What's this court going to do if that comes here? These are completely unenforceable. But under these proposed rule amendments, the amendment to Rule 101.1 of the Supreme Court rules, the bar says, let's take out violations of the Supreme Court rules and just put in any other rules of this jurisdiction regarding professional conduct of attorneys. I don't think this court would ever do that, because the court would say, sure, we'll discipline lawyers under rules that are adopted by who knows what board or body that we had no input into. And we're going to say to lawyers, we issue you a license, but you better comply with all these other rules out there most of which we don't know what they are. That, on behalf of myself and my today's constituency of about 12,000 other lawyers, I say to the court, bad, bad, bad idea. The rule as it sits now says, rules of professional conduct, Supreme Court rules, all of which have been thoroughly beat to death and argued about by this court. And this court says, look, you want to be a lawyer? Fine. Here are the rules governing your behavior. There are rules. We passed them. Here's your license. The rule is fine as it is. Should not be screwed with at all, especially not in this way. Secondly, on behalf of myself and my constituents of today, my constituent comes to me and says, okay, I had a bar complaint filed against me. I'm new to this. What are my rights? You say, well, you have some rights under the current rules. For example, the rules of civil procedure generally apply by Supreme Court rule. Oh, that's good. My constituent says, does that mean I get a full disclosure of the evidence from the bar that the bar has, a list of their witnesses, proposed testimony? Today, my answer is, you bet you do. That's what the rule says. But it won't say that anymore if you do what the bar is asking you to do. Because what the bar says is, and this is Rule 105.4, the bar wants to eliminate the mandate, and we set this out in the memo that we filed. The current rule says that the bar has to disclose all of its witnesses and all the documents that it has. The proposal, which is now in Rule 105.4, says it's entitled Disciplinary Rules of Procedure, Discovery of Evidence. The chairs, after consulting with their respective disciplinary boards, may adopt disciplinary rules of procedure subject to the approval of the Board of Governors. The disciplinary rules shall then require disclosure. But you don't have that right anymore. You have the right now, which I view in these proceedings. Look, if somebody says to a lawyer, we're going to take your license, we're going to end your professional career, then you have certain fundamental rights. And one of the rights you have right now is you go to a hearing, the bar has to disclose its evidence and give you a list, give you all the documents. There's a Brady element to this, but give you a list of its witnesses. Okay, fine. That's a pretty fundamental right if somebody is looking to end your career by taking your ticket. The bar now wants to change that to say, we may adopt a rule that says that. You don't have that right anymore. The chairman of the disciplinary panel may adopt that rule. Well, on behalf of myself and my constituents, when I saw that, I said, we're not in the habit of eliminating fundamental rights, and this is a very fundamental right, to know evidence and witnesses if you want to end my career. We're not in the habit of ending those rights unless there is a really good reason to do so. There has to be something very significant to cause that. Well, I would have said to my constituent, let's see what the bar says today about that. Because you can't simply say to the court, well, it's easier for us and more convenient if we don't have to do that. That is exactly what was said today. We're trying to streamline these procedures and make things easier. So we'd like it to be discretionary as to whether or not we have to disclose evidence and witnesses Whereas today, the accused, the person who's the subject of the discipline, has the right to those things. You know, there are fewer fundamental rights than that. The bar wants to change that and make it discretionary. I don't think that there is no reason, and there has been nothing presented today which would cause this court to change that. So it makes absolutely no sense. Because, and with all due respect to disciplinary panels, because I was the chairman of Southern Discipline for 8 or 9 years, so I know how this works. You can get a panel where you have one layperson and you have 2 lawyers, neither of whom is a litigator. And so when you say to a non-litigator, who is the chairman of the panel, I ought to get disclosure of witnesses and evidence, you can get an answer, no, I don't think so. And you throw up your hands and say, well, that's insane. You can't force me to go into a proceeding that'll cost me my profession. Blind? Yeah, that's what we're going to do. That's a possibility. That's why we have the right to evidence and witnesses absolutely set forth in the rules today. The court should not, under any circumstances, mess with that. Lastly, there has been, and those are the 2 main points I want to make, and they're really fundamental points regarding the hearings. The last point is with respect to the so-called task force. We've been here before when the American Bar Association, in what was called Ethics 2000, did a complete review and examination of the rules of professional conduct, the model rules. They worked on it for quite a few years, and they came out in 2000 with a revised bunch of rules, and they were a really, really magnificent piece of work. So this court said, and I'm pretty sure it was motivated by the Nevada Supreme Court, they said, you know what, we better have a look at our rules then. And everybody was in agreement on that. So the Supreme Court and the Board of Bar Governors put together a statewide commission, and they called it the Ethics 2000 Commission or Committee, I can't remember which. It got underway in 2002, and we worked off of the ABA's model rules. And that commission was a great bunch, because what happened was the members were selected from throughout the profession for particular areas of expertise. I can't remember everybody that was on it. Steve Wilson was the chairman. Jeff Stemple from Boyd was on it. Rob Baer, who was bar counsel at the time, was on it. Marshall Willick was on it from the family law division, and you know, he served a valuable purpose among other things. I was on it. We had a couple of other people, and there were people from the rurals and from northern Nevada. I think there were about 12 people, and it was a really good body. And we then did the proposed amendments to the Nevada rules to bring them not out of the dark ages, but they were old. And we proposed them to the Supreme Court along with the Board of Governors, and they were pretty much adopted by the Supreme Court in May of 2006. So it was about a 4-year, shouldn't have taken 4 years, but it did, process. If you want to seriously undertake a look and some revisions of these rules, that's the way to do it. I'm not criticizing what the Board of Governors did, but you get a small, select, intertwined group to, you know, put what they would like to see in the rules. You're not going to get what we got out of the Ethics 2000 Commission, which was a really, really, really good piece of work. And that's, if there is going to be a task force, That's how to do it, and it's easy because people are happy and willing to serve on that, because the finished product is not only going to be very high quality, but it's also going to serve the bar and the public very well. Questions?
No? Thank you,
Okay,
Mr.
thanks very much.
Thank you.
Good afternoon, Justices. Joshua Gilmore. May it please the court. I will follow and try to be brief. I don't want to cover what's been covered. I want to jump kind of where he left off, talking about the disciplinary rules of procedure, right? Because we have the Supreme Court rules right now that guide us. But as the court knows and saw in the comments, the Board of Governors has also adopted their own disciplinary rules of procedure, which is great, but the amendments now before you would elevate those above the rules of civil procedure and above the rules of appellate procedure. So right now, and this is under SCR 119, it says, unless otherwise provided by the Supreme Court rules, the Nevada rules of civil procedure apply and the Nevada rules of appellate procedure. So that has come up on service with complaints and timing for disclosures and things like that, right? Which works. And so the interplay there comes up at times. But what they have now proposed is to say, except as provided in the Supreme Court rules or the disciplinary rules of procedure, the rules of civil procedure apply. So now what's happened is, if the Board of Governors adopts a rule of disciplinary procedure that's different from what the rules of civil procedure apply, that will now take precedent in a bar matter. And our concern is those rules don't come before this court, like the rules of civil procedure do, rules of appellate procedure. And so from our perspective, we applaud the idea of trying to put together rules to, again, try to make it efficient while preserving fairness and due process. But at the end of the day, we can't take the power away from this court to decide how that process is supposed to run. This court sets the parameters, sets the guidelines, and we work within it. And to now say that disciplinary rules of procedure can be adopted by a very small body outside the purview of this court, and then take precedent over rules that this court enforces every day in cases that come before it, we think goes too far and cannot be done. So we have that in our comments, and so I wanted to follow from the last one to say that to me actually can open the door for even more substantive changes to how this process is done, and this court wouldn't see it unless it came up on appeal in a proceeding. And rather than have that come up piecemeal, I think we have to look at that now and say we can't go so far as to suddenly allow a body outside of this court's purview to adopt rules that control this process that we don't get to look at. Admonitions you've heard a lot about. The only thing I will add is I do think they should be available in a formal hearing. I can tell from representing a lot of clients that have gone through the disciplinary process. You know what matters? Seeing that reprimand on the State Bar's website. All said and done. That's, we live in a digital age now, right? Social media is huge. Online reputations are huge. That's a big deal. Yes, it's public if somebody knows how to go find it. And I think that's true for a lot of records, right? If you really go digging, right, you can find a lot of things that are public, but not necessarily at the touch of Google, right? So if you ask a lot of attorneys, a reprimand attached to their Nevada Bar website, that's a big deal. That is, right? And that, in their sense, and what I've gathered from representing attorneys through this process, that's public, right? That's what they think about. An admonition, that would not be in play, right? You'd go through the formal process, you'd have the hearing, and if ultimately a panel decided, based on the standards and the learner factors, that the admonition is appropriate, then that should issue. It won't be on the bar's website. Your name won't be in the Nevada World. So yes, perhaps somebody can run that down, right? But at the end of the day, that's not the Bar Council's problem, right? That's not the Board of Governors' problem. That's the attorney's problem. But nothing I've seen under the ABA model rules for disciplinary enforcement or the standards for lawyer sanctions take the admonition out of the equation simply because the attorney has now decided to go forward with the process. So I don't want to speak more on admonitions than that, but I just want to add that from the perspective of clients I know, that should still be available to them because it does mean something
So
whether
you
it shows
favor
up.
the amendment of the rules to permit admonition as a form of discipline, but you would allow that to be an option throughout the proceedings rather than one at the inception that's gone if you don't take it.
Exactly right. Your Honor.
Okay, thank
Is
you.
that a formal hearing panel would still have that option, would still be an
And you're saying that's the way in which admonition as an option works in other jurisdictions that follow the model rules and offer that?
Yes, and that's the way. I mean, if you look at the standards, it's an option under, if you're dealing with conflicts, if you're dealing with incompetence, if you're dealing with, disobeying the public trust. There's always disbarment, suspension, reprimand, admonition. Admonition is always an option, right? It doesn't say in there that third option for all those different potential areas of wrongdoing comes off the table simply because you've decided to go to a contested hearing. And so I do think ultimately the Bar Council has the right to argue at these hearings, right? We don't think these facts fit an admonition. And that's always within their purview to do that, right? As Bar Council talked about, you have a rule violation, we take up the mental state, we take up whether there was injury to the client, aggregating and mitigating factors, and then we have guidelines on where you pencil out what you score, whether you fit a reprimand, whether you fit an admonition. And so the rules as amended take that off the table completely. We simply say that should still be on the table. And that way panels ultimately get to decide. And we also know that
Right now it's not an option at all anywhere.
Correct, not an option at all. So then you go to a formal hearing, and as Bar Council has talked about, you argue for letters of caution, right? That's the argument. I think there's argument for it being a form of discipline. If you look at some of this court's prior rulings suggesting it is discipline, it has been imposed by panels and then published in sort of older Nevada lawyers where that might have been more frequent. So that is what happens. But I do think it should be something that attorneys should be able to argue for at formal hearings. As a function of that change, then something else they did, and we have this in our notes under SCR 105. The way it happens now is talked about. Screening panel may issue a reprimand, and then you have a right to object. If you don't, it becomes final. I don't know why, even if we add the admonition as a layer of discipline, why a screening panel shouldn't still be allowed to offer a reprimand in addition to an admonition, right? It's just another option. Either way, the attorney would still have the right to object, right? The difference with a screening panel would be saying, I'm issuing you a reprimand. That is public, and you as an attorney would know that. Or I'm issuing you an admonition, not public, but if you don't want that on your record, you still have a right to object. So the way the rules have been, the amendments now take away the screening panel's right to issue a reprimand, such that the screening panel is left with dismiss, admonition, referral to mentoring, probation, diversion, right? Or file a complaint. And you file a complaint, that's fine. There's a huge cost to that, right? There's time. It obviously eats up the Bar Council's resources. And at times, you have a lawyer who may get a proposed reprimand, and they may not like it, but they may say, you know what, I don't want to spend the time, the cost. Obviously, there's greater risk. So I would submit that while we welcome adding an admonition and believe that should be an option at the formal hearing panels, I don't know why we're taking away the screening panel's right to also recommend a reprimand. There's nothing that was in the petition to explain that. Switching gears, the petition suggests changing the rule on suspensions to use language that say it would generally not be for less than 6 months. Nothing was offered to explain why we would add that language, but I know and I hear that will then become the presumption, right? That if suspension is on the floor, right, you score out for that. Now it's 6 months unless, good cause is shown to go below that. This court ultimately decides all suspension cases, right? Any recommendation from a panel comes up to this court for automatic review. But I don't know why panels would not be able, should have a default that they should be recommending suspension for 6 months unless some other showing is made. That's not in the, if you look at the specific annotated standards for imposing lawyer sanctions, again, depending on theft of property, incompetence, communication, suspension, and then ultimately the rules suggest, flexibility, and ultimately you're guided by the facts of the case, right? Some cases may warrant 1 month. Some cases may warrant 3, 6. So I think the rule right now allows suspension. I don't understand the basis for sort of creating a presumption for 6 months or less. Finally, I'll close with this. There's talk about dismissals now being formally serving as notice, which in a sense means they're going to come into future hearings, right? So if you get a dismissal with cautionary language, that's now going to come into future hearings. Currently, that's not allowed under the rule, right? And that becomes an issue where you look at the prejudicial effect of that. I was accused of a rule violation before. A panel did not find clear and convincing evidence that I violated the rule. But, you know, screening panels suggested bar counsel give me some guidance going forward. But now I have to deal with the prejudicial effect of that dismissal in a subsequent proceeding. And so that really is doing indirectly what the rule says bar counsel shouldn't be allowed to do directly. So, again, we haven't seen the reason for submitting that. The rest of our comments have been in here. I know the court's been at this a long time, so if anybody has any questions for me, I will leave it at that.
Questions? No, thank you.
Thank you.
For your comments. We'll take one more speaker in Las Vegas, and we'll turn to Carson City after this, and we'll come back.
Good afternoon. My name is Dana Oswalt. I'm vice chair of the Southern Nevada Disciplinary Panel. I've been on the disciplinary committee since 2017, and I just wanted to briefly touch on admonitions. I think it's a good thing to add to the choices that the panels have. In a panel, I can tell you right now that if there was a prior dismissal with letter of caution, we don't know about it. I was part of the disciplinary task force in 2021. We did not address rule changes. We addressed the structure of the discipline process in Nevada. As far as the panels are concerned, though, Mr. Hoagie brought to my attention at the Board of Governors meeting when we discussed these potential rule changes that someone had 7 letters of caution. But the panel never knew about it because it's not discipline and it can't be brought up. The benefit of the admonition is that it allows for the progressive discipline that everyone seems to want. The panel would know about the history that's involved, whereas I don't know if I was sitting on that panel or not, but I didn't know, or that panel didn't know, that this person had been in front of the panel with 6 prior letters of caution and then got a 7th one. I can tell you right now, if I'm sitting on that panel, those 6 prior walking the lines would have affected my decision making as far as issuing another letter of caution. And that's something that when I brought it up at the Board of Governors meeting, it dawned on me that folks who are not intimately involved in the disciplinary process don't know that. And so the admonition gives some boundaries as far as that's concerned, but it also makes sure that there's transparency to the panel, because the panel doesn't always get all of the information that goes back and forth between the respondents and the bar, and we're just dealing with the information that's in front of us. And so I'm open to any questions that any of you all may have, but I just wanted to make sure that in practice, the letters of caution aren't anything as far as a new charge coming up or moving forward.
Anyone have any questions?
Thank you.
All right, thank you, Anna. All right, turning to Carson City, do we have any speakers?
Good afternoon, Justices. Kate Flokini, Assistant Bar Counsel at the State Bar. I just have a few comments that I wanted to follow up on. Am I good?
Yes.
Okay, I beeped. Sorry. I wanted to highlight in particular the history of a letter of reprimand. Prior to 2007, they were considered private, as Mr. Clark highlighted for the court. And then in 2007, there was a change to Supreme Court Rule 121, which made all matters public once the matter was concluded, and that meant that the letters of reprimand were what we referred to as discoverable. Even though they weren't published, they were discoverable and available to the public who knew how to ask for them. Between 2007 and I think it was approximately 2015, it was between 15 and 17, there was a concern that we were failing to adequately disclose letters of reprimand to the public or make them available to the public because you had to know how to ask the right questions. It wasn't on the website. People didn't know how to find it. And so the rules were revised to make it clear that letters of reprimand should be published in their full format rather than simply discoverable. So as long as a matter when it's concluded is public record, then an admonition, if a complaint has been filed, will go back to that spot, that weird spot where the public could ask for it, but we're not offering it. And the change was made in between 2015 and 2017 in order to protect the public's confidence in our profession. It was felt that having that nuance to the letter of reprimand's published status eroded the public's confidence in our ability to protect them. And so I think that's a main concern. If the complaint is public and the answer is public, and then the result becomes private and either isn't published or can't be found without asking the perfect question, we will go back to a scenario where perhaps the public's perception of the integrity of our profession is eroded, and I don't think that's where anybody wants to go. So if the complaint's public, then the discipline has to be public at the end of the day. I'm a strong proponent of having this extra step of a private admonition, but I want it to not erode the public's confidence in what we're doing. I don't want us to go backwards unnecessarily. Two other comments that I wanted to make with respect to probation being added, the idea of probation. I think that was added in conjunction with the idea of a stayed suspension. So there would be probationary terms. Probation would be related to some sort of discipline that's on the record, and so the terms of probation would be treated differently than terms of a diversion, because a diversion, once concluded, results in a dismissal, which is different than if there's a sanction issued at the end of the probationary term. So that's the distinction between diversion and probation. Finally, I wanted to address Mr. Kennedy's comment about the disclosure provision that is in 105, Supreme Court Rule 105, Section 4. That language was taken from 105 to subsection D, that is related to disclosures that had to be made in conjunction with the notice of hearing. And in part, it is meant to address the issue that has come up because in the disciplinary proceedings becoming or being more of a civil beast in the way that they're handled, we do initial disclosures. Those are required by the disciplinary rules of procedure. So very early in the case, we do initial disclosures to respondent's counsel or respondent. We ask that respondent do similar initial disclosures because there's no reason to hide the ball. We provide all of those documents, we disclose all of those witnesses early on in the case. Then we have to make sure that 30 days before the hearing happens, we do it again in order to comply with the current wording of 105.2 sub D. By moving it to subsection 4, it provides that once the initial disclosures are made, we don't have to go through that additional redundancy, that additional step of making those disclosures a second time. Often nothing changes between initial disclosures. I would say almost always nothing changes between initial disclosures and the final disclosures that are made with the notice of hearing. And so that is in part why that provision was moved to the end. So I appreciate the opportunity to address those particular items and for the court's consideration of this docket item.
Thank you. Are there any other speakers in Carson City? All right. Seeing none, we'll turn back to Las Vegas. Do we have any other speakers? Mr. Baird?
Madam Chief Justice, members of the Supreme Court, wow, what a moment for me. My name is Rob Baer. I was the bar counsel for the State Bar for 17 years, municipal court judge, district court judge for 10 years. And it's wonderful to see the faces that I'm able to stand this close to. I didn't file any comments. This was rather slow coming to me, but as time went on, I sort of felt duty bound respectfully to be here today as a resource, not necessarily a cleanup hitter 2 hours into a hearing, but in any event, I just felt like, you know, something came over me where I thought I'd at least show up and see if I could be a resource to be helpful. So I sat over there and I sort of took some notes, and I'd like to be quick as I possibly can. I sort of feel like I should have driven up to the Supreme Court today in the DeLorean, sort of back to the future instead of the Jeep that I have. But in any event, I do just want to say a few things quickly. A procedural comment. I was the reporter for the Ethics 2000 Commission that Dennis talked about. That did take a period of time to go through because that was actually a wholesale revision of all the rules, each and every one of the rules, which did result in the change, by the way, from the rules of substance, from Supreme Court rules to the rules of professional conduct, consistent with the way the ABA does it. I know that we had a lot of late night meetings. We had cameo appearances from Justices Hardesty, Cherry, and Douglas. I distinctly remember Justice Cherry wanting 2 sandwiches at one of those meetings, so I remember it specifically. But in any event, in listening to all this, respectfully, what I would suggest is the litmus test or barometer as to what to do now procedurally. I would have to say I agree that some sort of effort, though of course, I got to tell you, I respect the volunteer service of chairs and vice chairs of the Northern and Southern disciplinary boards, the Board of Governors, the bar president, and all those at the bar. I'm sure it's all brought forth in good faith. It's just that, to me, the issue as to what to do procedurally, I think, comes back to significance of what's going on. I'm sure we all have seen ADKTs over the years changing some rules that are rather ministerial in nature, and so, of course, you're not going to have a task force or a commission established to go over those type of ministerial changes, but it seems to me these are significant. I mean, again, I get up here 2 hours into a hearing and you see what we're dealing with. And so, respectfully, I think it does make sense, and I would volunteer to be on such a commission if asked. We did that with lawyer advertising, too. I think also Justices Hardesty, Douglas, and Cherry participated when we created the lawyer advertising rules in Nevada. So that's sort of a procedure, again, with a sort of the underlying issue being how significant is it? Significant enough? Let's put a commission or a task force together. Seems to me all this really is. Editorial comments quickly. I took some notes. I listened to some of the questions. Justice Kadish asked a few. Chief Justice, you said, so it's discipline or bust. This idea that an admonition has to come only from a screening panel, and if a screening panel offers it and a lawyer who's the respondent on the hot seat says, I don't want it, then it's no longer available. That wouldn't be consistent with the ABA rules, I don't think, by the way. And the whole effort, consistent going back in time, even to the Ethics 2000 time, was to try to be consistent with the ABA. So that's an anomaly right off the bat there. But again, the Chief Justice said discipline or bust, and I think the Bar Council said, well, and you see this as the logic here, well, let's just give a reprimand because it's already public. And I heard what Ms. Flocini just said. Let's give a reprimand, it's already public. Respectfully, editorial comment on that, I liken it to a situation maybe where somebody's charged with a minor offense in the criminal world, a DUI or misdemeanor type offense, and they're told, plead guilty, you don't go to jail. If you don't plead guilty, you're going to jail. Discipline or bust. And I've heard this idea of it's impossible to unring the bell. In other words, we filed a formal complaint, and this whole thing now is public. It's impossible to unring the bell.
Well, it's possible and it's certain that though you can't unring the bell, you can adjust the volume so it doesn't hurt your ears. You can adjust the volume to that bell. Meaning, letter of admonition, if given at a formal hearing panel, instead of discipline or bust, you get a letter of admonition if it's warranted, of course, at a contested hearing with someone like me, Dennis Kennedy, the lawyers at Lipson Nielsen, Josh Gilmore, you know, I think quality lawyers across the board. They want to give an admonition, this panel wants to give an admonition, so be it. It can adjust the volume down to a reasonable level. Meaning, if you get an admonition as opposed to a reprimand, which would be the only thing you can do by way of actual discipline, because the other part of this would be dismissal with cautionary language. So that's where the discipline or bust comes from. You go to the formal hearing, and it's dismissal with this cautionary language. The next thing above, with no admonition, is a letter of reprimand. Well, what does an admonition give you to lower the volume? An admonition gives you no magazine that if you're a lawyer, comes to your office, comes to your house, your family sees it, your contemporaries see it, everybody in your office sees it, the Nevada Lawyer Magazine, by rule, all public discipline, including reprimands, are in there. The admonition wouldn't be there. Lowers the volume. You're not in the magazine if you get an admonition. When the member of the public goes to look up, potentially, a lawyer on the State Bar's website, admonition is not there, but letter of reprimand is there. So again, volume is lowered with this admonition if it's warranted, of course. That's presupposed here. So you're not in the magazine, you're not on the website with an admonition. I will tell you, it affects people's malpractice insurance too. You get a public reprimand, it messes with your malpractice insurance. You get an admonition, not so much. Reciprocal discipline. It's a bear, pardon the pun. You get a public reprimand if you're licensed in other jurisdictions, you got to tell all the other jurisdictions about that. Some states do not require the admonition to be reported. Some do. It varies, but it's a lesser standard. Again, lowering the volume. Difference between a public reprimand and an admonition is just common sense. Think about it. You don't lose clients necessarily with an admonition because it's not on the website and it's not that publicly available, though it is public because it's part of a public hearing that started after a complaint. So it's a balance, I think, is what you're looking at here.
Mr. Baer, I have a question for you. What do you say to Ms. Flotini's point that the purpose of eliminating what was the equivalent of an admonition was to beef up public confidence in what the Supreme Court and the disciplinary proceedings are doing? That's question one. And then question two is, what do other states do with this dilemma that you have a private admonition in the sense that it's not truly private in that it can be requested and will be disclosed? Like, how big a deal is that anywhere else in terms of harming the public's confidence in the discipline and regulation of lawyers?
This court has said, probably since the time this court was actually the jury handling discipline cases. You know, the evolution of discipline in the state of Nevada was it started with you had your hearing from the Supreme Court. Then there was a period of time when I think the Board of Governors was the jury. Now you've delegated your authority to regulate the profession to the discipline boards in the state. Since the beginning of time, the only issue really, the only purpose for this whole thing was to protect the public. The regulation of our profession is designed to protect the public. So my answer is it's simply a balance. If admonition is warranted, then that's the result of the case. The public is protected by virtue of the procedure that was employed, that was a fair procedure to get to that point. I mean, it seems to me the public ought to be interested in fairness as well. It shouldn't be, again, discipline or bust. Fairness to show fairness. I mean, the public would be able to see the procedure and process that was used at a formal hearing. I mean, I've done a number of formal hearings now over the last 2 years since, there was a bit of a political anomaly that forced me to open my law office. And I did so, and I do represent lawyers at the bar. 75% or more of my time is probably doing other things like expert work in the area of professional responsibility and ethics. But nonetheless, I've had a number of hearings over there, and I've had some that resulted in something less than a public discipline. And typically the grievant, the person that files the bar grievance, testifies at the hearing, and they see the full day. Those hearings, the ones I've done anyway, the 9 o'clock in the morning start, 7, 8 o'clock at night, here comes the final decision from the panel. I mean, Mr. Hoagie can tell you about a case he and I had together in that regard. I've had some with a lawyer named Bruce Hahn at the State Bar, a retired DA out of Reno who does a number of cases for the bar. And I can tell you, from the perspective of the public, really the real party in interest, the grievant, they know a fair hearing was had because we spent a whole day at the bar and they testified. But I think it really is a balance. If admonition is the right choice, then it's the right choice. But it's not as though it happens willy-nilly. I mean, it happens it should be able to happen as an option in a formal hearing context is really what it is.
You would say that most of the states that have admonition as an option, one of the things that can be done, afford that option all the way through the hearing process rather than curtailing it at the early stage?
Well, I think so. I mean, I heard about Louisiana. I have to say, did I do a deep dive into things I've heard here? No, I didn't, because again, this sort of came to my attention, and it was actually just a few days ago I kind of said, okay, I'm showing up.
Fair enough.
So I'd be happy to do a deep dive into anything if I were part of some further effort here, which I would volunteer to do. But what I was going to say lastly then is it's about reputation. I used to do Bridge the Gap. Some people probably remember Bridge the Gap. When I was a lawyer at the bar, it was required that all the new admittees get together with me for an hour as part of this Bridge the Gap presentation. Some people liked the way I did that, so then it came to where I had to do 2 hours every year with all the new admittees. And then Bridge the Gap went away and things changed. But I would tell the new admittees, first thing I would tell them, and I would stress it, I actually use primacy, recency, whatever that Jedi technique is. I would say, look, I'm going to tell you this now, and then I would repeat it in my last thing. Nevada is small. It's a close-knit legal community. And guess what? It's still that way today. Right? If I mention any area of law, instantly in your mind, lawyers' faces pop in your head about who are the best in those areas, right? Criminal defense, family, bankruptcy, civil, personal injury, whatever it may be. Okay? Your reputation is your number one asset in this state. And as proud of this courthouse, the Hardesty courthouse, as we should be proud of that too. That it's still small enough to where your reputation precedes you. And that, more than anything else, is why this reprimand or bust is dangerous. Thank you.
Thank you, Mr. Bear. Any further commenters here in Las Vegas? Yes?
Good afternoon. My name is Russell Marsh, and I'm the current board chair for the Southern Nevada Disciplinary Panel. And I'm not here to give any rebuttal on behalf of the bar or the Bar Counsel's office. I'm here to represent the volunteer lawyers and lay people who sit on panels every month of the year. And to support the rule changes, I want to talk about two things, and I think one is what Mr. Bear just talked about. And I think we all agree, and I think this answers Justice Kadish's concern about having a range of options. I think we all agree that there was a hole that needed to be plugged after the last change in the rules. And I look at it from somebody who's sat as the chair of a lot of panels. I've sat as a chair of screening panels. And there was a dilemma a lot of times. And that dilemma was public letter of reprimand or dismissal with a letter of caution. This fills that gap. This, at least in most cases, is going to eliminate that dilemma for the people who are sitting on those panels. Now, I hear the fine lawyers here who often represent respondents in these type of cases say, but now the dilemma's on my clients. And that dilemma, in my mind, as somebody who's a criminal defense lawyer and was a prosecutor for over 20 years, is no different than the dilemma that criminal defendants face in justice court or in district court every day of the week. Here, Reno, the rules, it is the same type of thing. And I guess I feel a little bit harder because I'm a lawyer and we all want to make sure we're getting due process. I think of every person on this court as someone who polices due process. And if somehow the hypothetical gap that Mr. Kennedy says exists in this law now violates due process, you can figure that out. If for some reason disciplinary rules were passed that didn't provide for due process, or if a panel chair decided not to require lists of witnesses or evidence to be provided. I just don't see that ever happening. And if it does, you can police it. The other thing I wanted to address was the suggestion that respondents should be getting notice when information is shared. I think that the rule change about confidentiality is something that's been a long time coming and needed to be done. And I'm sure when Ms. Isaacson discovered what she did about Mr. Graham and the FBI found out about it, nobody would have expected the FBI to call Mr. Graham and say, hey, the bar just referred a bunch of information over here. Or a federal grand jury to be doing that, or even a grand jury in Clark County or anywhere else in the state. And so I just wanted to support the change. I think as somebody who was in law enforcement for a long time, I represent defendants now. I can see why people want notice, but there are certain things that should be done. I think it's a matter of public policy, confidential. And I'm happy to answer any questions you might have about the panels, at least here in Las Vegas.
So, Mr. Marsh, as part of when you're on the disciplinary panel as opposed to a screening panel,
yes,
would there not be some circumstances that after hearing the evidence, hearing from the respondent attorney and their attorney,
right,
that you might want to conclude that a private admonition would be the appropriate discipline in the end, after you hear all the mitigating factors and whatever is presented?
I understand that, and I think that might be the case, and I will say that under the proposed rules, as I understand them, we're back to the dilemma at the end that I talked about earlier, which is you're going to have to, there is an option to answer your question earlier, Chief Justice. There is always an option to dismiss and issue cautionary language or go forward with a public reprimand. Those are going to be the options if you adopt this rule change as proposed. I personally think that's fair to have that choice because that decision was made at the screening level and the person has rejected it. So it's just like any other plea negotiations or whatever you want to call it.
But as I understand it at this, and thankfully I've never been involved in this process, but from what I'm hearing today, when they're, if they get a proposed letter like that out of a screening panel, they haven't participated in the screening panel, may not know everything that was presented to the screening panel. And so, having to make the call at that point may be difficult.
Yeah.
I don't know if, I'm just asking for your response.
Again, that's like a dilemma that many criminal defendants face. And
But criminal defendants, whether they've even been arrested, maybe they just believe they're going to be arrested, or they're in the middle of their felony jury trial. They have the entire panoply of resolution available to them. They don't lose it because they got charged, a complaint was filed, a preliminary hearing was set, they were bound over. They have that entire time all available options to them to seek resolution. So we can't really make this analogy, and I've heard it several times today, that this is just like plea offers in criminal resolution. It's not. You're telling somebody if you refuse something at this stage, you could never ask for that again. And somebody could never impose it again, even if it seemed entirely appropriate. So how can that be fair?
Well, I mean, the analogy I can see as a criminal practitioner is when you have mandatory minimums or you have specific sentences that have to be given, like in a DUI or something like that, where if you go through the trial, the judge's hands are going to be tied. They can't give probation at that point. Now, I guess what you're saying is the DA could, in the middle of a trial, and this could happen, I've done it, where you say, okay, I still think there's a resolution that could be had, and we're going to do that. And the defendant could go along if that's, or he could propose something. You're just saying that this option, which right now doesn't exist at all, okay, should be available at all times of the proceedings. And that's a decision you guys have to make as the court in deciding whether you're going to adopt the rules as proposed or not.
One other question I had. I mean, as you settle the panel moving forward, let's assume this change occurs that's being requested under, and I'll just talk for a moment, Rule 1011, that changes the rules that can apply to attorney conduct from Supreme Court rules, rules of professional conduct, to rules of professional conduct and any other rules. What are those other rules in your mind that the panel would be applying to people for their conduct?
Well, here's what they're not, is I don't think I remember my office had a big laugh out of the use of the word creed, and I shouldn't blame President Armeni for that. But I think by the terms of that very creed, it says that it's not an enforceable document. So I would certainly think you couldn't get in trouble for that. Just like, I mean, when I was a federal prosecutor, we couldn't be held. Well, I mean, you have the U.S. Attorney's Manual, right? And it says right in it, you can't enforce this against the Department of Justice. Ultimately, that's something that if you adopt the rules as proposed, you'll need to decide on a case-by-case basis that comes before it.
But shouldn't we decide that before we adopt the rule?
And just take that language out?
Have some specificity before we adopt the change as to what's going to apply to people so they kind of know before, you put that rule into effect. And it'd be nice, right? I guess I just don't know why we would move away from the defined rules that were in place, Supreme Court rules, rules of professional conduct, so attorneys and people would have some notice of what will apply to them.
I don't want to get into a jurisprudential argument with anybody on this court because you'd bury me, but it's the balancing that happens every time you write a prescriptive law about what you're going to ban and what you're not. Okay, and there's a huge debate out there right now about over-criminalization, over not criminalizing enough, and how much notice has to be given. I mean, I represent somebody in a federal antitrust case. You try to tell me what in the Sherman Act tells somebody that they can't engage in a certain type of conduct. There's no notice at all.
Right.
Okay. However, I think that if we're talking about other rules that are passed down by courts, those have traditionally been covered by the current rules because it's an ethical violation to violate a court order or to disobey a judge, right? So I don't know what the answer is to the slippery slope on that. It's really, again, up to you whether you want to deal with that on a case-by-case basis or deal with the language now.
It's been suggested a couple times today that perhaps the formation of some sort of task force might be prudent. Do you have any opinion about that one way or the other? Would you guys entertain the establishment of some type of exploratory committee or task force to review? I mean, if these rules need to be overhauled, that's fine, but maybe get more stakeholders involved?
Well, I feel like the current proposed rules are a good intermediate step. Mm-hmm. I also sat on the committee that looked at more global changes, and we didn't look at these type of things. Like Judge Baer, I volunteer to be on that task force. Unlike Mr. Kennedy, I'm not going to be the chair for 8 years. I can tell you this will be my last year, and so I'll be would be happy to do something like that. I think that the main reason that these current rules are being proposed is, keep in mind, the volunteer lawyers who are panel, or the chairs of panels, or even what I do, are not professional judges. All right, and so what do you do when you have people like that? Or it's like dealing with the police. You want to be as clear as possible about what the rules are, and I think the vast majority of the proposed changes are simply trying to do that. So I would be in favor of both. Approve the rules, don't delay making the necessary changes, and if you'd like to propose a task force, great. Like I said, I'll sit on it. I know the two vice chairs sitting there, probably, I want to speak for them. They probably would too. Our chairs up in Reno as well. So,
and I would like to say, I echo Rob Baer's comment, appreciation for what you guys do as volunteer lawyers. It's an amazing job that you guys are doing, and we appreciate it. I think I speak for everyone up here when I say that. We really appreciate your efforts.
Yeah, and I know there's been kind of some, and this isn't answering your question, it's more of a conclusory comment. I'm happy to answer more questions. But there's been some suggestion that we're too concerned about efficiency and consistency and not enough about the individual rights of lawyers. I think you have to have all three. But I will say, and I don't take any credit for this at all, I think it's the bar and the Bar Council, but there has been more efficiency. Even with the pandemic, I think there has been more consistency, as you know from the rulings that you've been issuing, that you've been agreeing with what we've been doing. And so I think all of that's good. I can't think you just knock that because, being efficient a bad thing. I think it's a good thing. But I think you do have to take due process into account as well. Do you have any other questions?
No, thank you.
Thank you very much.
Have any other public comment in Las Vegas? All right, seeing none. Any public comment in Carson City? All right, at this time then, and I just note for the record, we certainly have a prerogative to limit the time associated with public comment. These issues are important. They affect a lot of people, a lot of lawyers in the state. Want to make sure that everybody had an opportunity to fully and fairly address these matters. So thank you to all the speakers and to the individuals who sent written comment. This matter will now stand submitted. We'll consider these go forward. Thank you very much.